state's motion in limine to exclude evidence or separate civil suits against defendant and or Rust Productions. And you know, if you're going to do a reply, you're going to need to figure out how you're going to do that. 3 minutes for the reply.
Thank you.
Okay.
I'll be brief. This one's
and I hate to tell you, I'm going to cut you off right away. Okay.
Understood, Your Honor. Your Honor, in this particular case, as the court is aware, there have been multiple civil lawsuits filed against Rust Production and against the defendant himself. Mr. Joel Souza, one of the state's witnesses, filed a civil lawsuit that I understand, has since been settled. There are 3 other state's witnesses, or 4, I believe, other state's witnesses who have pending civil lawsuits. We would respectfully ask that the court preclude the defense from cross-examining first Mr. Souza about his settled civil lawsuit. And there's a case right on point, which I cited in the motion, which is United States versus Whitehead. It's a U.S. 10th Circuit Court of Appeals decision, 562 Federal Appendix at 701, wherein the court affirmed the district court's denial of cross-examination on a civil lawsuit that was related to the criminal case, but that had since been settled before the criminal case went forward. And that's the issue with regard to Mr. Souza. The fact that he had a civil lawsuit and settled it is irrelevant and should not be allowed. With regard to the other witnesses, Your Honor, although we understand and the state acknowledges that under State versus Santillanes, the court noted that the pendency of a civil action by prosecuting witnesses seeking damages is a proper subject of inquiry. But the court also recognized that it's proper if the civil action is for the same offense that is being tried. And that's where the state respectfully submits there is a distinction between the pending civil lawsuits that 4 of the state's witnesses have versus what the court looked at in Santillanes. My understanding is that the pending civil lawsuits that the 4 state's witnesses have to do with intentional infliction of emotional distress and negligence as a whole in the filming or during the time that this filming was taking place between October 6th and October 21 of 2021. So it's not specifically related to the charge that the defendant is facing. Now, if someone had a pending wrongful death lawsuit, I would concede that that is germane and is subject to cross-examination. But because there is a difference between the civil lawsuits and this pending criminal prosecution, we would respectfully request that the court deny or preclude the defense from questioning these witnesses about their pending civil lawsuits. Unless the court has any questions, Your Honor. Thank you.
Your Honor, the defense has no present intention of questioning Mr. Souza about his settled lawsuit. I'm not waiving that issue, but I don't think the court needs to get there today. The rest of this issue is quite easy. This cross-examination was done during the Armour's trial, as the court no doubt remembers. In that case, there was 0 financial motive. In this case, there is suits against Mr. Baldwin directly, an extreme financial motive. And number 3, the lawsuits are exactly on point. It almost actually looks, if you look at the lawsuits versus the state's case, like they copied and pasted it. And I know this case seems in some ways like a civil negligence case, but it literally looks like they may have copied and pasted part of the lawsuits. So they're directly on point. None of their cases say what they claim. The case law on this is clear. It's actually one of those issues that's universal amongst all 50 states and all courtrooms in this country. You can always cross-examine a witness about their motive and bias. You can always ask them if that's the reason they're testifying in a certain way. And that's what the Confrontation Clause promises us, and that's what the Constitution demands. I have nothing further.
Any reply?
Just very briefly, Your Honor, it's a fine distinction, and it's made in State versus Santillanes. If the civil action, and I quote, was for the same offense being tried in a criminal action, absolutely agree, it would be subject for cross-examination. But I would respectfully submit that there are differences here between the civil actions and this criminal prosecution. So we'd ask that the court preclude any cross-examination.
All right, the court makes the following ruling. Evidence of pending lawsuits against defendant by testifying prosecution witnesses is proper impeachment evidence. The motion is denied.